Chapter 28 Secured Creditors' Rights and Remedies Part 1. Priorities 1. Why priorities matter. The basic rule under the Bankruptcy and Insolvency Act (BIA) is that ordinary unsecured creditors share the proceeds of the bankrupt's assets ratably in proportion to the relative sizes of their claims. S-141. Certain creditors can obtain priority over unsecured creditors by obtaining. Chapter 28 Secured Creditors' Rights and Remedies Part 1. Priorities 1. Why priorities matter. The basic rule under the Bankruptcy and Insolvency Act (BIA) is that ordinary unsecured creditors share the proceeds of the bankrupt's assets ratably in proportion to the relative sizes of their claims. S-141. Certain creditors can obtain priority over unsecured creditors by obtaining security over the assets of the debtor. In addition to the rights of secured creditors, certain other creditors are given special rights against specific assets of the debtor in priority to ordinary unsecured creditors. These special priority rights include landlord rights of distress for rental arrears, liens and deemed trusts given by statute to various government agencies or employees for unpaid employee-related remittances, and most recently, statutory charges for unpaid wages and unpaid pension contributions under the BIA. In certain circumstances, these priority claims will rank ahead of the rights of secured creditors too. Personal Property Security Act security. A lender and other creditors can obtain priority for their claims against a debtor over other creditors by obtaining security. This security can take various forms and can range in scope, from security over only specific assets of the debtor to security over all of the debtor's personal and real property. The effect of the security in each case is to give the secured creditor rights against some or all of the assets of the debtor in priority to the debtor's other creditors when the security becomes enforceable. To achieve priority, it is not enough for a secured creditor to obtain a written security agreement executed by the debtor. In order to obtain priority, a secured creditor must also take certain steps to perfect the security interests created by the security agreement. 2.1 Perfecting security. In the case of security that is governed by the Personal Property Security Act, PPSA, the secured creditor must follow the appropriate steps to obtain a perfected security interest. Perfection generally requires that attachment has occurred pursuant to S11(2) of the PPSA and either a financing statement has been registered, in the prescribed form, pursuant to S23 of the PPSA and S16 of the Minister's Order under the PPSA, or the secured creditor has obtained possession of the collateral. Attachment occurs when the secured party obtains a written security agreement, signed by the debtor and describing the collateral. B. Value is given, and C. The debtor has rights in the collateral. In lieu of registration of a PPSA financing statement, it is also possible to perfect a security interest in many kinds of collateral by possession or, in the case of uncertificated securities, by control. Perfection by possession is most common with respect to certificated securities, because perfection by possession of other types of personal property would usually prevent the debtor from having use of the collateral and therefore is not practical. 2.2 The relevance of title ownership. Even if the debtor does not legally hold title to a specific asset because title has been retained by the seller or lessor of that asset, the consensual security given to a secured creditor by the debtor or non-consensual liens imposed on the debtor's assets may still attach to that asset. Section 2 of the PPSA provides that the PPSA applies to any transaction that in substance is found to create a security interest, without regard to form. If the PPSA applies to the transaction, the priorities of claims over the assets subject to that transaction will be governed by the priority rules in the PPSA regardless of whether there has been a retention of title by the other party to the transaction, such as in a personal property lease or conditional sale contract. A reservation of title only matters if the PPSA does not apply to the transaction, that is, the transaction does not in substance create a security interest. The PPSA lists both conditional sale contracts and leases of personal property as transactions to which the PPSA could apply if in substance they create a security interest. If the PPSA applies, a lessor or conditional sale vendor may lose its rights to its goods unless it can establish priority to those goods under the PPSA priority rules. Case law is clear that where a conditional sale contract reserves title until payment in full is received from the purchaser, the PPSA applies to that transaction because title is being reserved to secure the payment of the purchase price. With respect to leases, the case law is not as clear, and reference needs to be made to the various indicia established by the courts to distinguish between leases that in substance create a Security interest, financing leases, and leases that do not. True leases. 3. Non-PSA security. In the case of security that is governed by a statute other than the PPSA, in order to ensure that the most beneficial priority available is obtained, it is necessary to ensure that the formalities and registration requirements of the applicable statute have been satisfied. For example, in order for a real estate mortgage to have priority over subsequent transfers or encumbrances, it must be in the form required by the Land Registration Reform Act and must have been registered against title to the land. 3.1 The relevance of title ownership. Reservation of title may be relevant to determining the priority of non-PPSA security. For example, in determining the priority of security granted under S-427 of the Bank Act, title does matter. Title also matters in determining the priority of a landlord's distress rights. The priority issues arising in respect of both S-427 Bank Act security and landlord distress rights are discussed below. 4. Secured creditor priorities. 4.1 PPSA priorities. 4. 1. First to register rule. The PPSA's general priority rules for collateral other than for investment property are set out in S30. Under S30, 1. Where priority is to be determined between two security interests perfected by registration, priority will be determined by the order of registration regardless of the order of perfection. This rule is important because S45, 3, of the PPSA permits a secured creditor to file a financing statement prior to the execution of a security agreement with respect to any collateral other than consumer goods. The result is that a secured creditor who has registered a financing statement first in time may obtain priority over a subsequently registered secured creditor, even though the subsequently registered secured creditor may have obtained its security from the debtor first. Moreover, where a priority contest is between a security interest perfected by registration and a security interest perfected other than by registration, i.e., possession, S30, 1. 2 provides that priority is determined by when the security interest perfected by registration was registered, not when it was perfected. If the security interest perfected by registration was registered before the security interest perfected other than by registration was perfected, the former has priority. The benefits of registering first can be even more significant when S45, 4, of the PPSA is taken into consideration. Subsection 45, 4. Provides that a single financing statement may perfect security interests created in more than one security agreement. 4. 1. 2 First to perfect rule where the priority contest is between two security interests perfected other than by registration. S30, 1. 3 states that priority is determined by the first to perfect. 4. 1. 3 First to attach rule where priority is to be determined between unperfected security interests. Priority is to be determined by the first to attach. S30, 1. 4. 1. 4 Deemed trust. Subsection 30, 7. Of the PPSA provides that a security interest in an account or inventory and its proceeds is subordinate to the interest of a person who is the beneficiary of a deemed trust arising under the Employment Standards Act, 2000 or the Pension Benefits Act. As discussed below, the Supreme Court of Canada recently held that on the wind-up of a defined benefit pension plan, the Pension Benefits Act creates a deemed trust over certain of the employer's assets for the amount necessary to fund the wind-up deficiency. Most deemed trusts, including this deemed trust, do not have priority in a bankruptcy. 4. 1. 5 Unperfected security interests. The consequences of failing to perfect a security interest are significant. For example, under S20, 1. Of the PPSA, an unperfected security interest is subordinate to the interest of a person who has a perfected security interest in the same collateral. B. A person who has a lien given under any other act or by a rule of law or who has a priority under any other act. C. A person who causes the collateral to be seized through execution, attachment, garnishment, charging order, equitable execution, or other legal process. And D. All persons entitled by the Creditors Relief Act, 2010 or otherwise to participate in the distribution of the property over which a person described in item C. above has caused seizure of the collateral or the proceeds of such property. In addition, under S20, 1, B, D, an unperfected security interest is not effective against a trustee in bankruptcy, b, a transferee of chattel paper, documents of title, instruments, or goods who takes under a transaction that does not secure payment or performance of an obligation and who gives value and receives delivery thereof without knowledge of the security interest, and c. a transferee of intangibles other than accounts who takes under a transaction that does not secure payment or performance of any obligation and who gives value without knowledge of the security interest. Therefore, if a secured creditor has an unperfected security interest at the date of bankruptcy, it will not have priority over a trustee in bankruptcy. If it perfects its security interest after the bankruptcy, it will be subordinate to the rights of the trustee in bankruptcy for 1. 6 purchase money security interests PMSIs. An important exception to the first to register rule is the priority that can be obtained by a creditor obtaining a purchase money security interest, PMSI. A PMSI is a security interest taken or reserved in collateral to secure payment of all or part of its price or taken by a person who gives value for the purpose of enabling the debtor to acquire rights in or to the collateral S1. 1. If the holder of a PMSI follows the requirements set out in S33 of the PPSA, the PMSI will have priority over any other security interest in the same collateral granted by the same debtor. In other words, the PMSI will have priority over pre-existing security interests in the same collateral. To obtain PMSI priority, a creditor with a security interest in collateral other than inventory, i.e., equipment or intangibles, must perfect its security interest by registration before or within 15 days after the debtor, or a third party at the debtor's request, obtains possession of the collateral as a debtor S33. 2. Or, in the case of an intangible, before or within 15 days after the attachment of the PMSI in the intangible, S33. 2. B. If the collateral is inventory, the secured creditor must do the following under S33. 1. In order to obtain PMSI priority, I perfect its security interest by registration. 2. Give notice in writing to every other secured party who has registered a financing statement showing inventory or accounts as collateral before the secured creditor's registration. And 3. Complete steps I and 2 above before the debtor, or third party, obtains possession of the collateral. The PMSI notice in 2 must state that the person giving it has or expects to acquire a PMSI in inventory of the debtor, described by item or type. S33. 1. C. If more than one PMSI has been granted in the same collateral, S33. 3. Gives priority to the seller of the goods. In order to establish PMSI priority, it is important for the PMSI holder to retain evidence as to when the equipment was delivered into the debtor's possession in order to demonstrate that the creditor has satisfied the timelines necessary to establish PMSI priority. Accordingly, many PMSI holders will obtain an express, dated acknowledgement of receipt by the debtor. If the creditor does not follow the applicable steps under S33, but is otherwise perfected, it would be perfected but would not have acquired the special priority of a PMSI under S33. Therefore, the creditor would not obtain priority over any pre-existing security interests in the same collateral. If there is no pre-existing security interest registered and perfected, the creditor would not benefit from any PMSI priority. Subject to S20. 3. Of the PPSA, if a PMSI in collateral is unperfected, it will be subordinate to the trustee in bankruptcy and any person who causes the collateral to be seized through execution, attachment, garnishment, charging order, equitable execution, or other legal process. Subsection 20. 3. Deals with situations where an execution creditor or representative of creditors takes control over collateral before the holder of a PMSI in that collateral has perfected its PMSI. Subsection 20. 3. Allows a holder of a PMSI to obtain priority if it registers a PPSA financing statement within the timelines set out therein, even if it is not so registered at the time control is assumed by a legal process or on the date a person's status as a representative of creditors of the debtor begins. The subsection provides that a PMSI in collateral other than an intangible, perfected by registration before or within 15 days after the debtor or a third party at the debtor's request has obtained possession of the collateral, is effective against a trustee in bankruptcy and has priority over the interest of any person who causes the collateral to be seized through execution, attachment, garnishment, charging order, equitable execution, or other legal process. If the PMSI collateral is an intangible, Similar priority is accorded to the PMSI provided that the PMSI is perfected by registration before or within 15 days after the attachment of the security interest in the intangible. If a lease transaction is part of a sale-leaseback, the equipment lessor will not be able to claim PMSI priority because the definition of purchase money security interest in S1(1) of the PPSA expressly excludes a transaction of sale by and lease back to the seller. An equipment lessor or conditional sale vendor who has registered a proper financing statement under the PPSA but who has failed to meet the timing or notice requirements under S33 to obtain PMSI priority, may still be able to obtain priority over other secured creditors with an interest in the same collateral by obtaining estoppel, waiver, or no interest letters or subordination agreements from the prior registered competing creditors. There are certain priority provisions in the PPSA that provide additional protection to PMSIs. For example, S38 of the PPSA provides that the priority given to vacation pay and pension deemed trusts under S37 of the PPSA does not apply to PMSIs. As well, the special priority provisions relating to accessions under S35, 2b of the PPSA, discussed below, expressly do not apply to PMSIs. 4.1.7 Special priority rules for fixtures and accessions. Fixtures. The PPSA contains special registration and priority rules for fixtures and accessions. A fixture is not defined in the PPSA. Therefore, reference must be made to the common law to determine whether the special rules for fixtures under S34 of the PPSA apply. Generally, in determining whether a good is a fixture, the courts have looked to the degree of annexation and whether the good constitutes an improvement to the real property. For the purposes of obtaining priority in a fixture under the PPSA, the creditor should register notice of the security interest in the prescribed form against title to the real property pursuant to S54 of the PPSA, commonly called a fixture filing, with limited exceptions. Registration of a fixture filing against title to the real property will give priority to the holder of the security interest over all subsequent interests acquired in the real property after registration of the notice. The nature and extent of a secured creditor's priority will be affected by the timing of the creditor's security interest attachment to the fixture. Section 34 of the PPSA sets out the special rules relating to fixtures. Subject to S34. 2. A security interest in goods that attached before the goods became a fixture has priority as to the fixture over any person with an interest in the real property. If the security interest in the good attached after the good became a fixture, the security interest only has priority over any subsequently acquired interest in real property, but not over any person with a registered interest in the real property at the time the security interest attached, unless that person has consented in writing to the security interest in the fixture or disclaimed an interest in the fixture. S34. 1. A security interest in the goods attaches when the debtor executes a security agreement. The secured creditor gives value, and the debtor has rights in the collateral. S11. 2. Subsection 34. 2. Provides that notwithstanding the foregoing, a security interest in fixtures is always subordinate to the interest of a subsequent purchaser for value of an interest in the real property and a creditor with a prior encumbrance of record on the real property, to the extent that the creditor makes subsequent advances. If the purchase or subsequent advance was made or contracted for without knowledge of the security interest and before registration of the fixture filing against title to the real property, therefore, it is important to register a fixture filing to obtain priority over purchasers and subsequent advances. B. Accessions. Accessions are defined in S1(1) of the PPSA as goods that are installed in or affixed to other goods, like the special priority rules for fixtures, subject to SS35, 2, 3, and 37 of the PPSA. The priority of a security interest in accessions is affected by the timing of the attachment of the creditor's security interest to the accession. A security interest in goods that attached before the goods became an accession has priority as to the accession over the interest of any person with an interest in the whole. If the security interest in the good attached after the good became an accession, the security interest only has priority over any subsequently acquired interest in the whole, but not over any person with an interest in the whole at the time the security interest in the accession attached, unless that person has consented in writing to the security interest in the accession or disclaimed an interest in the accession. S35. 1. Subsection 35. 2. Provides that notwithstanding the foregoing, A security interest in an accession is always subordinate to the interest of a subsequent purchaser for value of an interest in the whole and a creditor with the prior perfected security interest in the whole to the extent that the creditor makes subsequent advances. If the subsequent sale or subsequent advance under the prior perfected security interest is made or contracted for before the security interest is perfected, S35, 2, and except in the case of a valid PMSI, the interest of a creditor of the debtor who assumes control of the whole through execution, garnishment, or other legal process, if such control is assumed before the security interest is perfected, SS 35, 2, B, 3, 4, 1, 8 Special Priority Rules for Investment Property. The Securities Transfer Act, 2006 STA together with related provisions of the PPSA create a complex set of rules that governs the rights and obligations of issuers of securities, securities intermediaries, investors, and secured creditors. The STA and related PPSA provisions establish the concept of control over investment property. Investment property is defined in the PPSA as a security, whether certificated or uncertificated, security entitlement, securities account, futures contract, or futures account. S1, 1. Section 30.1 of the PPSA sets out the special priority rules for investment property. These rules should be carefully reviewed when determining the priority of a secured creditor over a borrower's investment property. Generally, the basic priority rules are as follows. Control has priority over non-control. A security interest perfected by control, by possession in the case of a certificated security and by a control agreement in the case of an uncertificated security, has priority over another security interest perfected otherwise than by control. PPSA, SS 30.1, 2, 3. 2 Security interests perfected by control rank according to priority in time. PPSA, S 30.1. 4A Securities intermediary has priority over other secured parties unless it otherwise agrees. PPSA, S 30.1. 5 Cutoff rules. A protected purchaser takes security free of any adverse claim. STA, S 70. Protected purchaser means a purchaser, which includes a pledgee secured creditor of a certificated or uncertificated security or of an interest in the security, who, I, gives value, 2. Does not have notice of any adverse claim to the security, and 3. Obtains control of the security. STA, S1, 1, B. A purchaser other than a secured creditor takes the security free of the security interest if the purchaser, I, gives value, 2. Does not know that the transaction breaches the security agreement, and 3. Obtains control of the security. PPSA, S28, 6, C. No action based on adverse claim may be brought against a person acquiring a security entitlement for value and without notice of the adverse claim. STA, S96. The PPSA also establishes a set of complex conflict of laws rules dealing with investment property in different jurisdictions. It is important that these conflict of laws rules also be reviewed with the priority rules set out above in order to determine what priority a secured creditor has over certain investment property for 1. 9 Bank Act security priority. Where the priority dispute is between security governed by the PPSA and security granted under S 427 of the Bank Act, the PPSA priority rules do not apply, and it is necessary to establish priority by reference to common law principles. Section 427 Security ranks behind the rights of a conditional sale vendor because S 427 security operates by transferring the debtor's title to the bank. Under a conditional sale contract, title in the purchased goods is retained by the vendor until payment in full by the debtor. If the debtor does not have title, the debtor has no title to transfer to the bank. In priority disputes between Bank Act security and security interests that are subject to the PPSA not involving conditional sale contracts, 2 decisions from the Supreme Court of Canada have held that priority is determined by the party that acquired the security interest first in time. If the PPSA security interest was acquired first, the Bank Act security would attach to the title of the debtor but subject to the PPSA security interest. This reasoning is based on S 428 of the Bank Act, which provides that the bank's title acquired pursuant to S-427 has priority over all rights subsequently acquired in, on or in respect of the property of a debtor. The court also held that this applies regardless of whether the PPSA security interest is registered under the PPSA. A PPSA security interest does not be registered to have priority over subsequent Bank Act security because registration is only relevant to competing priorities as between PPSA security interests. If the Bank Act security was acquired first, the PPSA security interest could not attach since PPSA security only attaches to the interests of the debtor and such interests would have already been conveyed to the bank under S-427. 4.2 Equipment leases. There is a distinction between a true lease, i.e., a rental arrangement, and a financing lease, which in substance creates a security interest. There used to be considerable uncertainty and litigation regarding the issue of whether a particular equipment lease was a true lease or a financing lease, the latter of which would be subject to the provisions of the PPSA. The PPSA attempts to simplify the uncertainty. It applies to leases of goods under a lease for a term of more than 1 year even though the lease may not secure payment or performance of an obligation S2. C. However, Part 5 of the PPSA, which governs rights and remedies, applies to a security interest only if it secures payment or performance of an obligation, and thus, does not apply to true leases. S57.1. As a result, true leases with terms of 1 year or more are subject to the conflicts, registration, perfection, and priority provisions of the PPSA, but they are not subject to the rights and remedies provisions under Part 5 of the PPSA. The definition of a lease for a term of more than 1 year is broad. S1. 1. It applies not only to any true lease with an actual term of more than 1 year but also extends to any true lease with the potential of having a term exceeding 1 year. Such as a lease for an indefinite term or a lease for a term of less than 1 year but which is renewable for 1 or more terms, the total of which may exceed 1 year. In addition, the definition covers an overholding lessee as permitted by the lessor. Therefore, even if the initial term plus any renewal thereof is less than 1 year but the lessee is entitled to retain uninterrupted or substantially uninterrupted possession of the leased goods for a continuous period of more than 1 year with the consent of the lessor, such a lease will become subject to the PPSA after the lessee's possession exceeds 1 year. There are 2 narrow exceptions. The PPSA will not apply to a lease, even if it has a term of greater than 1 year, if the lessor is not regularly engaged in the business of leasing goods, or the leased goods are household furnishings or appliances that are subject to a lease of land and the use and enjoyment of such goods is incidental to the use and enjoyment of the land. S1. 1. The provisions of the PPSA do not mean that the distinction between true leases and financing leases is not relevant. It is still relevant in both PPSA and non-PSA contexts. Under the PPSA, the distinction remains relevant in determining whether the enforcement provisions of Part 5 of the PPSA apply to a particular lease. Part 5 sets out various requirements, including the requirement to provide notices of disposition to the lessee and other interested parties and to account for any surplus. In the case of a true lease, the lessor's remedies will be governed by more lax common law principles and the terms of the lease agreement. For example, unless the lease provides otherwise, a lessor is entitled to retain any surplus from the sale of the leased goods at the end of a true lease. Outside of the PPSA context, the distinction between a true lease and a financing lease remains relevant. For example, S65.1. 4 of the BIA and S11.3 of the Companies Creditors Arrangement Act, CCAA, have been interpreted to provide that only a lessor under a true lease is entitled to continue to be paid following the lessee's filing for protection under the BIA proposal provisions or the CCAA 4.3. Execution creditors and execution creditors' rights against the debtor's assets are subject to the rights of secured creditors with perfected security interests. The execution creditor may obtain priority if the execution process has been completely carried out, including the seizure and sale of assets by the sheriff and delivery of proceeds to the execution creditor, before the secured creditor enforces its security. An execution creditor that has not completely carried out the execution process, including seizure, sale, and delivery of proceeds, will rank equally, or pari passu, with other unsecured creditors. In a priority dispute between an execution creditor and a secured creditor holding an unperfected security interest governed by the PPSA, The PPSA provides that the unperfected security interest is subordinate to the interest of the execution creditor if the sheriff has taken control of the collateral S20. 1. 2. 5. Statutory liens and deemed trusts for Crown Claims 5.1 General. In order to enhance the collection of certain kinds of statutory claims from the debtor, many federal and provincial statutes have created statutory liens and/or deemed trusts on the debtor's assets. A statutory lien is a lien imposed by statute over the debtor's assets without the need for a consensual security agreement executed by the debtor. A deemed trust is a trust created by statute in the debtor's assets in the amount required to be paid under the statute that is deemed to be held in trust by the debtor, separate and apart from its other assets, whether or not the debtor actually segregates these assets. 5.2 Pacific Standard Time Clearance Certificates. In addition to statutory liens and deemed trusts, some tax statutes, such as the Retail Sales Tax Act, require a secured creditor, receiver, or trustee in bankruptcy to remit any amounts owing by the debtor subject to the deemed trust, to the Minister of Finance, before any proceeds of security are distributed. Failure to do so results in the secured creditor, receiver, or trustee being liable for the amounts. Upon remittance, the secured creditor receives a certificate from the Minister of Finance certifying that all amounts subject to the deemed trust have been paid or acceptable security has been given to the Minister in respect thereto. S22. 5. 5.3 Types of statutory liens and deemed trusts. Generally, statutory liens and/or deemed trusts relate to one of the following three categories: amounts owing by the debtor to a government authority, i.e., property taxes; amounts that are collected or withheld by the debtor on behalf of the government, such as harmonized sales tax, where applicable, or goods and services tax and retail sales tax, where not applicable, and employee source deductions, i.e., tax source deductions and employment insurance and Canada Pension Plan remittances, which are deducted from an employee's pay by the debtor-employer for remission to the relevant government authority, or amounts that are owed by the debtor to others, such as claims of employees for vacation pay. The nature, scope, and priority of a statutory lien and deemed trust will vary significantly from statute to statute and will depend on the particular language of the statute in each case. Some statutes create statutory liens, some create deemed trusts, and others utilize both statutory lien and deemed trusts concepts. Some statutory liens require registration under the PPSA while others do not. Some deemed trusts and statutory charges have priority over pre-existing registered security, but only if the enabling legislation provides for such supra-priority, and some do not. As a consequence, when reviewing the priority of claims over a debtor's assets, possible statutory claims against the debtor should also be reviewed to determine whether any of these claims may have priority over the claims of secured creditors with a perfected PPSA interest over the debtor's assets. 5.4 Effect of bankruptcy. 5.4. 1. Reversal of priorities for Crown claims. The relative priority of many statutory claims against secured creditors may be significantly affected by a bankruptcy of the debtor. Pursuant to S86 of the BIA, the priority of a statutory lien and/or deemed trust may be reversed by a debtor's bankruptcy. Section 86 of the BIA provides that all claims of the federal and provincial Crown, including secured claims and all claims of a workers' compensation body, rank as unsecured claims in a bankruptcy or a BIA proposal, unless the claims are secured and have been registered in the manner provided for under S86 or 87 of the BIA. Furthermore, S67. 2. Of the BIA invalidates statutory deemed trusts in the context of a BIA proposal or bankruptcy unless the deemed trust is a real trust under ordinary common law principles. As a consequence of S86 of the BIA, it may be beneficial for a secured creditor to initiate or encourage the bankruptcy of a debtor in order to reverse the priorities that are otherwise provided for under statute. This is what is commonly referred to as a strategic bankruptcy, that is, a bankruptcy where the main objective is to reverse the priorities that exist in a non-bankruptcy scenario. An order lifting a CCAA stay of proceedings to allow the debtor to make an assignment in bankruptcy in order to reverse priorities is within the authority of a CCAA judge. The Supreme Court of Canada has held that the priority provisions of the BIA should apply to the distribution of proceeds of liquidation and that the order lifting the stay to allow for a bankruptcy to reverse priorities is appropriate in that It advances the underlying purpose of the CCAA because it fosters a harmonious transition from reorganization under the CCAA to liquidation under the BIA. 5. 4. 2. Exemption for employee source deductions. The most common statutory claims that are exempt from the application of SS 86 and 67. 2. Of the BIA are claims of the CRA for employee source deductions and claims of a provincial government for withheld but unremitted source deductions of a similar nature to those excluded for the benefit of the CRA CSS 67, 3, and 86. 3. Of the BIA, 5, 4, 3. Securing Crown claims. There are two scenarios in which Crown claims and workers' compensation claims can be secured claims, the priority of which is not affected by S 86 of the BIA. First, a statutory claim can be secured by security in the same way as may be obtained by persons other than the Crown. S 86. 2. The BIA does not expressly provide for any special priority to these claims, and therefore, it would appear that the priority of these claims would be governed by the same rules that would apply to similar forms of consensual security. Second, a statutory claim may be secured pursuant to S 87. 1. Of the BIA by way of the security provided for under special federal or provincial legislation for the sole or principal purpose of securing Crown or workers' compensation claims. Such security must be registered in the prescribed registration system prior to the date of the initial bankruptcy event, which is defined in the BIAS 2, to mean, in respect of a person, the earliest of the day on which any one of the following is made, filed, or commenced, as the case may be, a. An assignment in bankruptcy by or in respect of the person, b. A proposal under the BIA by or in respect of the person, c. A notice of intention to make a proposal under the BIA by the person, d. The first application for a bankruptcy order against the person, in any case, I. Referred to in S 50.4, 8, 57, or 61, 2, or 2, in which a notice of intention to make a proposal has been filed under S 50.4 or a proposal has been filed under S 62 in respect of the person and the person files an assignment before the court has approved the proposal, e. The application in respect of which a bankruptcy order is made, in the case of an application other than one referred to in d. above, or f. proceedings under the CCAA, in a bankruptcy or BIA proposal. This security is subordinate to other security interests if the necessary steps to make other security interests effective against other creditors were taken before the registration of the Crown or workers' compensation interest. S 87. 2. This type of security is only valid in respect of the amounts owing to the Crown or Workers' Compensation Board at the time the security was registered, plus any accrued interest thereon. S 87. 2. B. Several Crown claims can be registered under provincial legislation, including claims for tax payable under the Employer Health Tax Act, the Corporations Tax Act, and the Land Transfer Tax Act. These claims may be registered against a debtor's interest in land, including the beneficial interest of an unregistered owner or any leasehold interests held by a debtor, by filing a notice in the required form in the appropriate land registry office. These claims may also be registered by filing a financing statement against the debtor under the PPSA. By making such a filing, the Minister of Finance obtains a lien on any interest in personal property in Ontario then owned or thereafter acquired by the debtor. Outside of a bankruptcy, the lien has priority over any perfected security interest registered after the registration and any encumbrance or other claim registered after, or that otherwise arises after, the financing statement is registered. The lien does not, however, have priority over a PMSI. The notice under the PPSA is valid for 5 years and may be renewed. Outside of a bankruptcy, these claims secure all amounts from time to time owing by the taxpayer under the relevant statute while the notice remains registered. 6. Wage priority claims where any employer is bankrupt or subject to a receivership. A priority charge is given to unpaid employee wage claims, which ranks in priority to almost all creditor claims, secured or unsecured, pursuant to SS 81.3 bankruptcy and 81.4, receivership, of the BIA. Claims of a clerk, servant, traveling salesperson, laborer, or worker for unpaid wages, salaries, commissions, or compensation, including vacation pay but not including termination or severance pay, for services rendered in the 6-month period prior to the bankruptcy or receivership, are secured for up to $2,000. plus $1,000 of disbursements for traveling salespeople, by the employer's current assets. In a bankruptcy, the 6-month period begins 6 months prior to the date of the initial bankruptcy event and ends on the date of bankruptcy, if the debtor first files under the CCAA or if the bankruptcy is involuntary and disputed. The total time period covered could be more than 6 months. The statutory security created by SS 81.3 to 81.4 is limited to the current assets of the employer. Current assets mean cash, cash equivalents including negotiable instruments and demand deposits, inventory or accounts receivable, and proceeds from any dealing with those assets. S2. In the case of a bankruptcy, the current assets subject to the statutory charge are those of the bankrupt at the date of the bankruptcy. In the case of a receivership, the current assets subject to the statutory charge are those current assets in the possession or control of the receiver. A secured creditor has a preferred claim in bankruptcy under S-136 of the BIA to the extent its recovery is reduced by the priority charge for unpaid wage claims. The foregoing wage priorities described above also now apply in CCAA proceedings, where these wage priority amounts must be paid or arrangements made for the payment thereof before a court can approve a CCAA plan or asset sale in a CCAA proceeding. 6.1 Priority. The statutory charges granted under SS 81.3 to 81.4 of the BIA have priority over all unsecured claims, all secured claims, including secured claims under the PPSA, regardless of whether those claims were made or perfected before the wage claims arose, and most statutory liens and deemed trusts. They are subordinate only to very limited statutory claims such as those claims of unpaid suppliers under S 81.1 of the BIA and, in a bankruptcy, claims of the CRA for unremitted source deductions. Although the charges were intended to also be subordinate to CRA claims for unremitted source deductions in a receivership, due to differences in the language of the provisions between S 81.3 and S 81.4 of the BIA, that priority is uncertain. 7. Pension contribution claims where an employer is bankrupt or subject to receivership proceedings. Unpaid pension plan contributions also benefit from a statutory priority charge by virtue of SS 81.5 to 81.6 of the BIA. Sections 81.5 to 81.6 of the BIA establish priority for unpaid regularly scheduled contributions to certain pension plans prescribed by regulation by creating a priority charge over all of the debtor employer's assets, i.e., the charge is not limited to current assets. The statutory charge is limited to unpaid regularly scheduled pension contributions. It does not extend to special pension contributions or underfunded pension liabilities. Underfunded pension liabilities arise in defined benefit pension plans when the assets of the plan are insufficient to meet actuarial forecasts for what the plan's future liabilities will be. A secured creditor has a preferred claim in bankruptcy under S-136 of the BIA to the extent its recovery is reduced by the priority charge for unpaid pension contributions. The foregoing pension contribution priority applies in CCAA proceedings, where these amounts must be paid or arrangements made for the payment thereof before a court can approve a CCAA plan or asset sale in a CCAA proceeding. 7.1 Priority. The statutory charges under SS 81.5 to 81.6 of the BIA have priority over all unsecured claims, all secured claims, including secured claims under the PPSA, regardless of whether those claims were made or perfected before the pension contribution claims arose, and most statutory liens and deemed trusts. They are subordinate only to very limited statutory claims such as those claims of unpaid suppliers under S 81.1 of the BIA, claims for unpaid wages under SS 81.3 and 81.4 of the BIA, and in a bankruptcy, claims of the CRA for unremitted source deductions. Although the charges were intended to also be subordinate to CRA claims for unremitted source deductions in a receivership, due to differences in the language of the provisions between S 81.5 and S 81.6 of the BIA, that priority is not clear. 7.2 Underfunded pension deficiency claims. Sections 81.5 to 81.6 of the BIA apply only to regular pension contribution payments, not to underfunded pension deficiency claims arising under defined benefit pension plans. The Supreme Court of Canada recently held that on the wind-up of an Ontario defined benefit pension plan, the Pension Benefits Act creates a deemed trust over certain of the employer's assets for the amount necessary to fund the wind-up deficiency if the wind-up occurred before the insolvency or restructuring proceeding. However, the application of the court's decision has been limited, and the protection for pension claims have been generally limited to the extent set out in SS 81.5 to 81.6 of the BIA. Until the Supreme Court of Canada revisits this issue, there may continue to be some uncertainty over the deemed trust on a wind-up of a defined benefit pension plan. 8. Landlord Priorities 8.1 Landlord's right of distress. A landlord has the right to seize and sell assets owned by the tenant located on the leased premises in order to satisfy any rental arrears owing by the tenant, including any assets of the tenant subject to a security interest granted by the tenant. However, S. 31(2) of the Commercial Tenancies Act restricts the landlord's rights of distress or distraint to the assets owned by the tenant that are located on the premises. The result is that where the tenant does not have title to the goods, the landlord's right of distress only applies to the extent of the debtor's equity in the assets located on the leased premises. Therefore, a landlord does not have a right to distrain on goods that are subject to a conditional sale contract, which reserves title in the seller, except to the extent of any equity in the goods held by the tenant. If the goods have been partly paid for, a landlord who wants the benefits of any of the tenant's equity will have to pay out the balance of the purchase price owing under the conditional sale contract. The same rule applies vice versa. If the conditional sale vendor wishes to seize the goods for its benefit, it will have to pay the landlord the value of any equity in those goods paid for by the tenant. A similar result also arises where the secured creditor is a bank that holds security under S. 427 of the Bank Act. When a bank takes security under S. 427, it acquires legal title to the goods. Section 428 of the Bank Act provides that the bank's title acquired pursuant to S. 427 has priority over all rights subsequently acquired in, on or in respect of the property of a debtor. The landlord's right of distress has been held to be a right in, on or in respect of the property, and as a result, if the arrears of rent rise and thus the right to distress arises before the S. 427 security is taken, the bank's security under S. 427 will be subject to the landlord's distress rights, and therefore the landlord will have priority. Conversely, if the S. 427 security is taken by the bank before the arrears of rent rise and therefore before the right to distress arises, the bank's S. 427 security will have priority because the landlord's right of distress cannot attach to the tenant's assets once title has passed to the bank. Unless there is a stay of proceedings in effect under a court receivership, the landlord's right of distress will supersede a receiver's rights to possession where there is no reservation of title. A secured creditor can protect itself from this risk in 3 ways. First, it can obtain a waiver of distress from the landlord at the time the security is taken. Second, it can seek a stay of distress rights under a court receivership. Third, it can terminate the landlord's right of distress by causing the debtor to become bankrupt. The landlord may not distress on the trade fixtures of the tenant, even if removable. 8.2 Termination of leases is an alternative to the landlord's right of distress. A landlord typically will have the right under its lease to terminate the lease for failure by its tenant to pay rent under the lease. It is important to note that the 2 remedies of distress and termination are alternative remedies. If the lease is terminated, the landlord has no right to the tenant's assets located on the premises following the termination. In most cases where there are rent arrears, the landlord usually prefers first to distress for the arrears of rent and then, if necessary, to terminate the lease on the basis of other defaults by the tenant under the lease. The landlord's rights of distress and termination are significantly affected by a bankruptcy of the tenant. 8.3 Effect of bankruptcy. 8.3. One generally secured creditor may want to cause a debtor's bankruptcy not only to prevent the landlord's exercise of its rights of distress but also to prevent termination of the lease and preservation of the ability of the trustee in bankruptcy to assign the lease to a third party without the landlord's consent. This will occur in circumstances where the lease has terms favorable to the tenant, such as below market rent, and the landlord has reasonable prospects for letting the space on more favorable terms to the landlord. 8.3. To reversal of priority of landlord's right of distress upon the bankruptcy of the tenant. The landlord's right of distress against the goods of the tenant is replaced by a preferred claim under S. 136. 1. F. of the BIA for up to 3 months arrears of rent and 3 months accelerated rent to the extent permitted under the lease, limited to the value of the tenant's goods located on the premises at the time of the bankruptcy. If the landlord completes the distress prior to the tenant's bankruptcy and receives the proceeds of sale from the distressed goods, the landlord will be entitled to keep those proceeds, even if its distress was not conducted in compliance with the statute. If the landlord's distress is not completed at the time of the bankruptcy, either because the goods have not been sold or the proceeds have not been paid to the landlord, the goods or the proceeds must be remitted to the trustee in bankruptcy or to the secured creditor with a prior secured claim to those goods or proceeds. In either case, after deducting the landlord's costs of seizure BIA S73 4,8 3 impact of bankruptcy on right to terminate the lease. The landlord's right to terminate the lease is also affected by a bankruptcy. Subsection 38(2) of the Commercial Tenancies Act provides that upon bankruptcy, the trustee in bankruptcy is entitled to possession of the premises for a period of up to 3 months and has the right during that 3-month occupation period to elect either to retain or disclaim the lease. The trustee's statutory right of occupation in Ontario supersedes the landlord's right of termination. If the trustee disclaims the lease, the landlord is then free to take possession of the lease premises. If the trustee elects to retain the lease, the trustee is required to bring the lease back into good standing by paying all arrears of rent. The trustee also has the right under S38(2) of the Commercial Tenancies Act to assign a lease to another party, thereby obtaining some value for the estate. This statutory right of assignment applies even if the lease contains restrictions on the tenant's right to assign a lease without the landlord's consent. If the landlord refuses to consent to the assignment of the lease to the new tenant proposed by the trustee has the right, subject to certain conditions, including the payment of all arrears of rent, to apply to the court for an order permitting the assignment of the lease without the landlord's consent. 9. Changing priorities. There are various ways in which the priorities set out in the PPSA and elsewhere can be altered. Some of the main ways that the priority of the creditor can be altered are set out below. 9.1 Priority, subordination, and intercreditor agreements where there is more than one significant secured creditor of a debtor. The secured creditors may seek to confirm or alter their respective priorities by entering into an agreement between them that sets out the priorities between them, regardless of what priorities may otherwise attach to such security by virtue of the priority rules under the PPSA, other applicable statutes, or a common law. These types of agreements are typically referred to as priority agreements, subordination agreements, or intercreditor agreements. The names are often used interchangeably, although they are in fact technically different. These agreements are important, not only because they alter the priorities otherwise accorded to the parties under the law, but also because they often contain restrictions against enforcement by the parties by requiring the consent or prior notice to other parties prior to commencing any enforcement steps. Typically, a priority agreement or subordination agreement will involve an arrangement in which the creditor parties agree that the security of one of the creditors has priority over the security of the other creditor, and that, conversely, the other security is subordinated to the priority of the first. An intercreditor agreement is usually more complicated than a priority or subordination agreement. It can involve each creditor agreeing that their respective security rank equally, i.e., on a pari passu basis, so that the proceeds of any recovery are to be shared between them on a prorated basis. Alternatively, it can set out different ranks of priority between the creditor parties to the agreement over different categories of assets, which may be subject to caps or limits on the amount of the proceeds subject to the priority. For example, creditor A has priority over the proceeds of all equipment collateral, and creditor B has priority over all inventory collateral, or it can be more complicated, such as creditor A has priority over the proceeds of all equipment collateral up to $9, and then creditor B has priority over the proceeds of the equipment collateral up to the next $Y, and so on. The priorities and subordination priority, subordination, and intercreditor agreements can be in respect of security only or in respect of debt, i.e., payment of debt is subordinated in non-enforcement scenarios and security, whether it is a priority, subordination, or intercreditor agreement. The agreement will typically specify notices and consent requirements for any demand and/or enforcement proceedings and set out how proceeds of any realization are to be applied by the creditor parties. A priority, subordination, or intercreditor agreement is simply a contractual agreement between the parties that sets out a different order of priority between the creditor parties that would otherwise occur under existing statutory or common law rules. It is therefore common for these agreements to contain provisions stating that the priorities reflected in the agreement will continue to apply, regardless of the order of registration or perfection of the security held by the parties or any priorities otherwise afforded to the security under applicable statute or common law. Because a priority, subordination, and intercreditor agreement is only an agreement between parties to it. Those who are not parties to the agreement are not bound by the priorities set out in the agreement. Priority agreements typically provide that the agreements do not confer any rights on the debtor or any other person. This sometimes has led to interesting priority issues. For example, if creditor A has priority over creditor B under the priority agreement, creditor A is unprotected and therefore is subordinate to trustee in bankruptcy, while creditor B is perfected and therefore has priority over the trustee in bankruptcy, who has priority over the debtor's assets. Creditor A can obtain priority because creditor B will claim priority over the trustee under its security and then, pursuant to the terms of the priority agreement, would pay any proceeds of those assets over to creditor A to the extent creditor A's priority under priority agreement. It is common in priority agreement to contain a provision that any proceeds received by a party from assets over which another party has priority under the agreement are to be held in trust and promptly remitted to the other creditor. 9.2 implied subordination. Even if there is no priority, subordination, or intercreditor agreement, it is still possible for priority of the secured creditor to be affected by operation of 38 of the PPSSA, which provides that a secured party may, in the security agreement or otherwise, subordinate to the secured party's security interest any other security interest. Implied subordination has been found to arise in connection with provisions from permitted encumbrances in a loan or security agreement. This typically releases in the context of negative pledges contained in loan or security agreement pursuant to which debtor covenants not to create permanent encumbrances to assist against assets except for certain exceptions, often referred to permitted encumbrances. If the security document permits the creation of permitted encumbrances without expressly stating that the provision of permitted encumbrance does not automatically grant priority to such permitted encumbrances unless otherwise provided by law, and an implied subordination could be found to have occurred. The most common type of permitted encumbrance for personal property is the PMSI. To address this risk, the loan and security documentation should expressly provide an acknowledgement by the borrower and lender that nothing in the loan or security agreement, including provisions for any permitted encumbrances, is intended in any way to subordinate any of the security interests granted by the borrower to the creditor. 9.3 Correcting errors and reprotecting security. As soon as a creditor discovers that a debtor who has tinted security may be in financial difficulty, it is important for the creditor to commence a review of its security to confirm that the security was validly given and properly protected or registered where required at the time the security was tinted and there have been no intervening events that require any amendments to the security or the registrations. If errors or deficiencies are discovered, steps should be taken immediately to correct by registering an financing change statement under PPPA or by obtaining new security. It may be possible for a creditor to correct an error or address a deficiency in its security and registration still be able to maintain the same priority or at least priority over other secured creditors and trustee in bankruptcy. An unprotected security interest is subordinate to the interest of a trustee in bankruptcy. So, at a minimum, any correction that results in an unperfected security interest becoming perfected will obtain priority over a trustee in bankruptcy. This could be beneficial if there is any residual value in the assets after the claims prior secured creditors are satisfied. The PPPSA requires that on the occurrence of certain events, i.e., a change in the debtor's name, an amendment to a PPPSA financing statement must be filed to continue the perfection of the security interest as well, unless the financing statement was registered for a perpetual period. Renewal must be filed in a timely manner under PPPSA. Accordingly, even if the security interest was properly registered at the time of the registration and was first in priority, circumstances may arise that change this status. When the security interest becomes unperfected, loses any priority it previously had over other perfected security interests. This situation can be rectified and the original priority reinstated by filing the required financing change statement, i.e., in the case of a debtor name change, by filing a financing change statement showing the debtor name, or in the case of an expiry of the original registration, by filing a financing statement to record the security interest again. Subsection 36 of the PPSA provides that once the required financing change statement or financing statement in the case of an expiry is filed, the original security interest deemed to have been continuously perfected from the date of the original registration, subject only to the interest of any parties who may have acquired rights in the collateral in the intervening period when the security was unperfected, such as other secured creditors, the debtor, or purchasers of the collateral. In this case, the correcting financing change statement or financing statement will not be effective against those intervening interests because at the time the intervening interests were acquired, the security interest was unperfected. In some cases, these rules can lead to complicated priority disputes because some of the rules require amendments to be filed knowledge-based. That is, the requirement to file a resist within a certain time period after the secured creditor obtains knowledge of an event, such as a debtor name change. If the error or deficiency relates to the original PPSA financing statement, the secured creditor cannot obtain the benefit of the deemed continuous perfection under S36. Since there was no perfection to begin with, the secured creditor should still immediately take steps to rectify the error or deficiency by filing a financing change statement or a new financing statement. If there is any possibility that the secured creditor could rely on the original financing statement, then it is recommended that a financing change statement be filed. The financing change statement will give the secured creditor affected security interest at least from the date of registration of the financing change statement. This procedure leaves it open for the secured creditor to claim that even though it may have contained an error or deficiency, its original filing was also properly perfected. The secured creditor may argue that the error or deficiency was not materially misleading and therefore be cured by S46 of the PPSA. Subsection 46. 4. Provides that a financing statement is not invalidated nor is its effect impaired by reason only of error or omission or in its execution or registration unless a reasonable person is likely to be misled materially by the error or omission. A significant issue in this regard will be whether the error would prevent a reasonable person from discovering the security interest under a PPSA search. After discovering an error or omission, some secured creditors will register a financing change statement and a new financing statement 9.4 perfect by repossessions or certain types of collateral. Instead of filing a financing statement under the PPSA, a creditor may perfect its security interest by possession pursuant to S22 of the PPSA. The reperfection rule under S36 of the PPSA referred to above only applies where the security interest is perfected at each stage by registration, not possession. As a result, if a security interest was originally perfected by registration and subsequently becomes unperfected, possession can perfect the security interest at time of possession. Possession will not restore the secured party's original priority over other creditors. 9.5 The strategic bankruptcy. A secured creditor may bring an application for a bankruptcy order against a debtor in order to reverse certain priorities that would exist in a non-bankruptcy scenario, since most crown liens and deemed trusts are eliminated in bankruptcy. Before filing an application for a bankruptcy order, a secured creditor should first confirm that its security is in order, i.e., properly executed and contains proper collateral descriptions. Properly perfected under the PPSA because an unperfected security interest is subordinate in priority to a trustee in bankruptcy. PPSA S21 B or properly registered in accordance with the requirements under the applicable statute, i.e., Bank Act, and is free from challenges of fraudulent conveyance, preference, or transfer at undervalue. Additionally, the BIA gives workers a priority charge over current assets of a bankrupt employer for unpaid wages, up to $2,000 per claimant, and gives pension beneficiaries a priority charge over all assets of a bankrupt employer for unpaid regularly scheduled pension plan contributions. BIA SS 81.3 to 81.6. A secured creditor should therefore attempt to determine the status of outstanding wage claims and unpaid pension contributions before determining whether to petition a debtor into bankruptcy, because the statutory charges for unpaid wages and pension contributions have priority over all secured claims except for CRA liens for unremitted source deductions and unpaid suppliers' proprietary claims on supplies. 10. Enforcing priority. 10.1 Determination of priorities. The priority of a secured creditor to proceeds of its collateral will be subject to review by interested parties such as other creditors of the debtor, a trustee in bankruptcy, or a receiver. In some cases, the court will determine the priorities of security. In order to determine the priority of a creditor's security, the creditor will be asked to provide a copy of its security documents, evidence of any registrations that have been made, and the particulars of the amount owing to it by the debtor. A secured creditor who is subject to the PPSA is required to provide such information upon request under S18 of the PPSA. If the creditor is claiming a PMSI, the creditor will be required to provide evidence of when the property was delivered into the debtor's possession or third party on the debtor's behalf. And, in the case of a PMSI claimed over inventory, copies of any PMSI notices that were issued and proof of receipt thereof by the parties entitled to notice. Reviewing security and resolving priority issues takes time. In certain cases, the value of the assets will dissipate over time, or there may be a ready buyer who wants to purchase the assets on an expedited basis. In these cases, in order to maximize the value of the assets, competing creditors can agree to allow the assets to be sold and the net proceeds of sale to be held in trust or in a third party escrow pending agreement or settlement between the parties or an order of the court as to the priorities to the sale proceeds. 10.2 Judicial determination of priority. Where parties are unable to resolve a priority dispute, the court may be asked to adjudicate. In certain cases, the parties may already be subject to court proceedings, so there is a ready forum to hear the dispute. In other cases where there are no existing legal proceedings, i.e., in the case of a private receivership, one of the parties to the dispute would need to commence a proceeding to ask the court to determine the priority in dispute. If the priority dispute relates to security that is governed by the PPSA, a party may make an application under S67, 1, c, of the PPSA, which permits the court to make any order necessary to determine questions of priority or entitlement in or to the collateral or its proceeds. The court may not have jurisdiction if the priority dispute is between a PPSA security interest and non-PSA security. Part 2. Repair and Storage Liens Act 11. Introduction. In addition to the Crown statutory liens referred to above, there are several other types of liens that are created by statute that may give priority over properly perfected security interests under the PPSA or other consensual security interests or charges granted by a debtor to a creditor. One of these is a lien in favor of unpaid repairers and storers under the Repair and Storage Liens Act, RSLA 12. Repairers and repairs. A repairer is defined under S1, 1, of the RSLA as a person who makes a repair on the understanding that the person will be paid for the repair. A repair is an expenditure of money on or the application of labor, skill, or materials to an article for the purpose of altering, improving, or restoring its properties or maintaining its condition. Repair includes the cost of transporting an article for the purpose of making a repair, the towing of an article, and the salvage of an article. Whether a certain service or expenditure of monies constitutes a repair for the purposes of the RSLA will depend on the facts of each case. For example, courts have held that software development and integration and the installation of a new locking system can be a repair, while the installation of a new sound system in a car cannot. 13. Storers. A storer is defined in the RSLA as a person who receives an article for storage, or storage and repair, on the understanding that the person will be paid for the storage or storage and repair, as the case may be. 14. Articles. The RSLA applies only to an article, which is defined as an item of tangible personal property other than a fixture. Fixture is not defined in the RSLA. Repairers of fixtures may be entitled to a lien under the Construction Act. 15. Overlap with the Consumer Protection Act, 2002 for repairs of vehicles, as defined in the Highway Traffic Act. A repairer must ensure that it is in compliance with the requirements of the Consumer Protection Act, 2002 in order to have a valid claim for repairs. 16. The RSLA lien. The RSLA creates two types of liens, the possessory lien, and the non Possessory lien 16.1 Possessory liens. The possessory lien entitles the repairer or storer to retain possession of the article until the lien amount has been paid. 1. Priority of possessory lien. A possessory lien under the RSLA has priority over the interests of all other persons in the article, including properly perfected security interests under the PPSA pursuant to S6 of the RSLA and S31 of the PPSA. Section 6 of the RSLA provides that a possessory lien has priority over the interests of all other persons in the article. Section 31 of the PPSA provides that where a person in the ordinary course of business furnishes materials or services with respect to goods that are subject to a security interest governed by the PPSA, any lien that the person has in respect of the materials or services furnished has priority over a perfected security interest, unless the act that creates the lien provides that such lien does not have such priority. 16.2 Non-possessory liens. 2. 1. Requirements to obtain a non-possessory lien. If the unpaid repairer or storer has given up possession of the article to the customer, it can still obtain a non-possessory lien in the article, pursuant to S7. 1. of the RSLA. Subsection 7. 1. provides that where an unpaid repairer or storer has given up possession of the article without having been paid in full, an unpaid repairer or storer who is entitled to a possessory lien under the RSLA may obtain a non-possessory lien against the article for the amount that remains unpaid. In order to obtain a valid non-possessory lien under the RSLA, the unpaid repairer or storer must obtain a signed acknowledgement of the indebtedness pursuant to S7. 5. and register the lien claim as required under S10. 1. of the RSLA. The RSLA provides that a non-possessory lien is enforceable against third parties only if a claim for lien has been properly registered under the PPSA. SS 9-10. 1. A non-possessory lien is registered by filing a Form 1C financing statement claim for lien in paper form or electronically with the Ontario Ministry of Government and Consumer Services in the same manner as a PPSA financing statement. 2. Priority of non-possessory lien. Subsection 7. 3. of the RSLA provides that a non-possessory lien in an article has priority over the interest of any other person in the same article other than an unpaid repairer or storer who has a valid possessory lien in the article under the RSLA, as between holders of a properly registered non-possessory lien claim and a validly perfected security interest under the PPSA. The non-possessory lien ranks in priority except in respect of any third party who has acquired rights against an article after the non-possessory lien arises but before the non-possessory lien was properly registered. RSLA. S10. 1. 16.3 Amount of lien effective July 1, 2016. Unpaid repairers or storers may, in the absence of a written agreement to the contrary, claim under SS 3, 1, and 4, 1. the amount that the person who requested the repair or storage agreed to pay, where no such amount has been agreed upon, the fair value of the repair or storage, or where only part of a repair or storage is completed, the fair value of the part completed. The factors to be included in the determination of a fair value for repair or storage or both are set out in S1 of General O. Reg 427/15, made under the RSLA. Unpaid repairers may only obtain liens for the unpaid principal amount of the repair and any reasonable costs and expenses associated with seizing and selling the article but not any interest on those amounts. RSLA. SS 28. 2. 3. Unpaid storers may include interest on money advanced by the storer in relation to the stored article. General S1. 2. 2. Amendments to the RSLA and the regulations thereunder that came into force on July 1, 2016. Reduce the time periods for which storage liens may be claimed for motor vehicles, and provide courts with a number of specific discretionary factors to consider in making a determination of reasonableness. These amendments are expected to reduce the value of claims secured by RSLA liens. 16.4 Bankruptcy. A properly obtained RSLA lien is treated as a secured claim in a bankruptcy, and therefore, its priority, like that of other secured claims, is not affected by a bankruptcy. Part 3. Enforcement of Security. 17. Introduction. The common law, the PPSA, the BIA, and other applicable statutes govern the rights and obligations of secured creditors and debtors. Generally, each step in the process of security enforcement is governed by rules of commercial reasonableness and reasonable notice of the secured creditor's intentions. If a secured creditor fails to meet the duties imposed upon it at any stage of the process, it may be liable to the debtor or others for damages. Generally, there are 6 steps in the security enforcement process. First, the loan and security documents of the secured creditor should be reviewed to ensure that the security has been properly granted and that the security interests have been properly registered or perfected in accordance with the PPSA, the Bank Act, or other statute, as may be applicable, to give the secured creditor priority over the debtor's assets it intends to enforce against. Second, notwithstanding the provisions in a security agreement that may provide that demand is not required before a secured creditor can enforce its security, a secured creditor must demand repayment of its loans from the debtor before it can enforce its security against the assets of the debtor. Third, pursuant to S-244(1) of the BIA, if the debtor is insolvent and the collateral granted to the secured creditor encompasses all or substantially all of the debtor's inventory, accounts receivable, or other property acquired for or used in relation to a business carried on by the debtor, the secured creditor must give 10 days notice of its intention to enforce its security in a form prescribed by the BIA. Fourth, the secured creditor must review the various remedies available to it to enforce its security and to take possession and control of the collateral. The secured creditor may obtain possession and control of the debtor's collateral directly, through a bailiff, agent, or privately appointed receiver, or through a court-appointed receiver and/or manager. Each of these persons is subject to certain statutory duties while in possession of the collateral. Fifth, before selling or otherwise disposing of or foreclosing on the collateral subject to its security, the secured creditor must allow others an opportunity to redeem the indebtedness owing by the debtor to the secured creditor by providing written notice to the debtor, other secured creditors, and others with an interest in the collateral. Lastly, in the disposition of the assets subject to its security, the secured creditor, its agents, or any receiver appointed by it must act in good faith and in a commercially reasonable manner. In considering which remedy to use in the enforcement of its security, the secured creditor will consider a number of factors, including the nature and location of the collateral, the estimated realizable value of the collateral, whether any opposition from the debtor or any other creditor or interested person is anticipated, whether the court's assistance is required, for example, to settle priority or value disputes or to provide a stay of proceeding, whether the business should continue to operate, and what costs and risks may be involved in continuing to operate the business and in the seizure and sale of the debtor's assets. 18. Making demand for repayment of the loan. 18.1 The demand and S-244 Notice 181. 1. The common law requirement for reasonable notice whether the indebtedness is payable on demand or pursuant to a term loan. The first step to enforcing security is for the secured creditor to demand payment from the debtor. This is because the common law requires that reasonable notice be provided to the debtor to pay the indebtedness owed to the secured creditor before the secured creditor is entitled to proceed with enforcement of its rights. This right of the debtor to reasonable notice is independent of the loan or security agreement and therefore is required regardless of whether the loan or security agreement requires that demand be made or contains any waiver of demand or notice. The principle behind reasonable notice is to give the debtor an opportunity to cure the default, redeem the loans, or initiate a restructuring of its debts. 181. 2. The S-244 BIA requirement for notice if the debtor is insolvent and the collateral granted to the secured creditor encompasses all or substantially all of the debtor's inventory, accounts receivable, or other property used in relation to a business carried on by the debtor. S-244. 1. Of the BIA requires that the secured creditor must give 10 days notice to the debtor of its intention to enforce its security in a form prescribed by the regulations. S-244 Notice. If there is any chance that the debtor is insolvent or that the collateral covered by the secured creditor's security constitutes all or substantially all of the inventory, accounts receivable, or other property of the insolvent person, a S-244 notice should be sent. The consequences of failing to give the notice could be material if the debtor ceases operations as a result of an improper enforcement. When the S-244 notice is served on the debtor, the secured creditor is prohibited from taking any further steps in the enforcement of its security for the 10-day notice period. There is some question about whether issuing notices of a secured creditor's intention to sell the property of the debtor subject to its security pursuant to the PPSA or any other applicable statute constitutes a step in the enforcement of its security. The general practice for secured creditors is to refrain from issuing such notices during this 10-day notice period. Similar to the common law requirement for reasonable notice, the S-244 notice overrides any provision in loan and security agreements that may authorize the secured creditor to enforce its security and/or appoint a receiver immediately following default without notice of any kind to the debtor. 18.1.3. Exemptions from S-244 notice in certain circumstances. The BIA provides that secured creditors may enforce their security without waiting the 10 days. These exemptions include the following. The debtor has filed a proposal under the BIA that does not include that particular secured party. The class of secured creditors to whom a proposal is made has voted against a proposal. A receiver has been appointed by the court or another creditor. The debtor has consented to the earlier enforcement of the security but only after the S-244 notice has been delivered to the debtor. S-244. 2.4. Notice is also not required if the debtor is bankrupt. The requirement under S-244. 1. Only applies to an insolvent person, which is defined in the BIA to expressly exclude a bankrupt. Clearly, if the debtor is bankrupt, the rationale for giving reasonable notice has become moot. 18.1. For contractual notice periods or other preconditions to enforcement in addition to the common law and statutory notice periods, the loan agreement, security documents, or intercreditor agreement, if applicable, may also contain additional contractual rights of notice or conditions before a secured creditor is entitled to exercise its rights of enforcement. For example, if the indebtedness arises pursuant to a term loan and maturity has not yet occurred, the secured creditor will have to establish that an event of default has occurred under the loan agreement before being entitled to demand payment of the term loan. Loan and security agreements may also give the debtor certain rights to cure defaults under the loan and/or security agreements after notice of default has been given by the lender. If the secured creditor intends to rely on these defaults, it must first wait until the curative periods have expired before demand can be made. Sometimes the secured creditor's conduct can affect its entitlement to demand. For example, a secured creditor may be found to have implicitly agreed not to demand payment in the particular circumstances during the course of negotiations or discussions with the debtor leading up to the demand. In order to avoid any unintended consequences, it is recommended that a secured creditor who is negotiating with the debtor in these circumstances make it clear that the secured creditor is reserving all of its rights and remedies, notwithstanding any negotiations or discussions, that any delay from proceeding with any such rights and remedies during such negotiations or discussions does not constitute a waiver of those rights, and that those rights and remedies are expressly reserved. 18.2 Reasonable notice. The 10-day notice period under S-244. 1. Of the BIA appears to be an attempt to codify the common law requirement for reasonable notice. In most cases, compliance with the requirements under S-244. 1. Of the BIA will be sufficient to satisfy the common law reasonable notice obligation with respect to insolvent debtors. In these cases, the secured creditor would concurrently deliver the demand with the S-244 notice so that both notice periods run simultaneously. However, S-244. 1. Does not expressly override the common law requirement for reasonable notice. As a consequence, if the debtor is not insolvent or if other special circumstances exist, a secured creditor may be required to provide more than the 10 days prescribed by S-244. 1. What is sufficient reasonable notice will depend on the particular facts in each case. Generally, reasonable notice is for a short period. In some cases, the common law requirement for reasonable notice may even be less than the statutory 10-day period required by the BIA. For example, where the secured creditor has a justifiable concern about the dishonesty of the debtor or the collateral being dissipated. Because the requirement for reasonable notice is dependent on the particular facts of each case, it is important for the secured creditor to review the circumstances prior to demanding and enforcing its debt and security against the debtor to determine whether the circumstances warrant a longer notice than the 10-day period required under S-244. 1. Of the BIA 18.3 Interim Receivers 1.8.3. 1. General. In certain cases, a secured creditor may seek to abridge the 10-day notice period required under S-244 by seeking the appointment of an interim receiver under S-47. 1. Of the BIA 1.8.3. 2. Preconditions to appointment. In order for the court to appoint an interim receiver, the court must be satisfied of all the following. The debtor is an insolvent person as defined in the BIA S-244 notice has been or is about to be sent to the insolvent debtor S-47. 1. The appointment of the interim receiver is necessary for the protection of the debtor's estate, or the interests of the creditor who sent or is about to send the S-244 notice. S-47. 3, 18. 3. 3 powers of the interim receiver. Interim receivers can be granted broad powers similar to those of a receiver appointed under the Courts of Justice Act, CJA. Interim receivers can be authorized to take possession of a debtor's assets and can be granted extensive rights and powers to investigate, locate, preserve, protect, and seize assets. In most cases, an interim receiver may only be appointed for up to 30 days. The court may appoint an interim receiver of all or any part of the property to which the S-244 notice relates. BIA S-47. 1. As the court considers advisable, the interim receiver may be empowered by the court to take possession of the property and/or exercise control over the property and the debtor's business. S-47. 2. 18.4 Section 243 Receivers. Section 243 of the BIA allows the court to appoint a receiver in respect of an insolvent person or bankrupt, with national authority, if it considers it just and convenient to do so. 4. 1. Powers of S-243 receivers. The powers of the S-243 receiver are similar to the powers of a receiver appointed under the CJA. The S-243 receiver may take possession of all or substantially all of the inventory, accounts receivable, or other property of an insolvent person or bankrupt that was acquired for or used in the course of that person's business. The receiver may exercise control over that property and take any other action that the court considers advisable. The only requirements for the appointment of a S-243 receiver are that a. The debtor be an insolvent person or bankrupt, and b. The appointment is, in the view of the court, just and convenient. As a result, reference to case law is important in assessing under what circumstances a court may find the appointment to be just and convenient. 19. Taking possession. A security agreement typically contains a right of seizure and sale in favor of the secured creditor upon default by the debtor, even if the agreement does not expressly provide for this remedy. As long as it is not expressly excluded, the right of seizure and sale is also granted to the secured creditor under statute. Typically, security agreements will provide that the secured creditor has, in addition to the listed rights and remedies, all remedies otherwise available to it under the law. Subsection 62, 1, of the PPSA provides that a secured party has, unless otherwise agreed to in the security agreement, the right to take possession of the collateral by any means permitted by law and to dispose of the collateral in accordance with S-63 of the PPSA, if the collateral is equipment. S-62, 1. Provides that the secured creditor can render the equipment unusable without removing the equipment from the premises, and such shall constitute deemed possession of the equipment. A secured creditor can obtain possession of collateral subject to its security in various ways. For example, the collateral can be seized by the secured creditor directly, by a bailiff or agent appointed by the secured creditor, or through a receiver or receiver manager appointed privately by the secured creditor under its security agreement, if so permitted by the security agreement or by the court. 19.1 Self-help remedies. A secured creditor can simply seize the collateral subject to its security itself. Typically, this self-help mechanism is used where the security is only over specific collateral, i.e., specific equipment. The secured creditor simply obtains possession of the collateral and sells it. This self-help remedy only works where the debtor is cooperative and does not seek to resist seizure of the collateral by the secured creditor. Even if a secured creditor exercises the self-help remedy, it is still subject to various statutory duties, such as the duty to act in a commercially reasonable manner in respect of its possession and sale of the debtor's assets under the PPSA, S-17, and BIAS 247, b. In certain cases, a secured creditor acting by itself may also be considered to be a receiver for the purposes of the BIA and therefore subject to certain reporting and other obligations. 19.2 Bailiff or agent. Instead of seizing the collateral itself, a secured creditor may choose to appoint an agent, such as a bailiff or an accounting firm that provides insolvency and receivership services, to assist it in seizing and realizing upon all or part of the collateral charged by the security agreement. 19.3 Interim order for possession. Where a debtor is not co-operative and resists seizure of the collateral by the secured creditor or its agent, The secured creditor may obtain the court's assistance by way of a motion pursuant to S. 104 of the CJA and R. 44 of the Rules of Civil Procedure for an interim order for recovery of possession. The motion is usually brought on notice to the debtor, but in certain circumstances, such as where the collateral is perishable or rapidly depreciating in value or where damage is likely to occur, the secured party may be able to obtain the order on an ex parte basis, without notice to the debtor. Because the interim order for possession is an interlocutory order, the court may require the secured creditor to pay into court or post a bond for an amount up to twice the value of the collateral. 19.4 Receivership. Typically, where the collateral comprises more than just specific pieces of collateral, such as all or substantially all of the assets of a debtor, a secured creditor will choose to enforce its security by either appointing a receiver or receiver manager pursuant to the terms of the security agreement or seeking the court's appointment of an interim receiver, S. 243 receiver, or receiver manager. The receiver is required to be a licensed trustee in bankruptcy. A receiver does not carry on the business. A receiver manager does. 20. Foreclosure is an alternative to disposing of the assets subject to the secured creditor's security. A secured creditor may choose to foreclose against the assets of the debtor, that is, to take the assets in full satisfaction of the indebtedness owed to it by the debtor. Section 65 of the PPSA sets out the procedure for accomplishing a foreclosure against the debtor's assets. Subsection 65. 2. Of the PPSA states that the secured party must first give 15 days notice of the proposed foreclosure to all those persons who would otherwise be entitled to receive a notice of sale under S63 of the PPSA. If no objection is made within that 15-day notice period, S65. 6. Provides that the secured party is deemed to have irrevocably elected to accept the collateral in full satisfaction of the obligation secured. This means that after the foreclosure takes place, the secured creditor has no residual right left to sue the debtor for any part of the indebtedness owed to it that was secured by the collateral. If a person has properly objected to the retention of the collateral within the 15-day notice period and, if required, has provided proof of the person's interest in the collateral in accordance with S65. 4. The secured party cannot retain the collateral and must proceed to sell it in accordance with S63 of the PPSA. A secured creditor's right to foreclose against consumer goods, as defined in S1 of the PPSA, is limited by S65. 1. Consumer goods are goods that are used or acquired for use primarily for personal, family, or household purposes. Subsection 65. 1. Provides that the creditor may not foreclose where the debtor has paid at least 60% of the indebtedness secured and has not agreed to any modification or renouncement of the debtor's rights under S65. 1. In those circumstances, the creditor must dispose of the collateral in accordance with S63. 21. Receivership. 21.1 Private receiverships. 2.1. 1. 1 Powers. A secured creditor is only able to privately appoint a receiver or receiver manager if its security agreement contains the right to do so. A privately appointed receiver has the rights assigned to it in its appointment letter. Those rights are dependent on the rights granted by the debtor to the secured creditor in the security agreement under which the appointment is made. A privately appointed receiver takes its instructions from the secured creditor who appoints it. 2.1. 1. 2 Appointment letter. The process for the appointment of a receiver is simple. A secured creditor can appoint a private receiver by way of an appointment letter. That appointment letter will typically state that default have occurred under the security agreement. Appoint the receiver under the security agreement to exercise all or only certain of the rights contained under the security agreement, set out over which assets of the debtor the receiver is being appointed. Even though the secured creditor's security may charge all of the debtor's assets, the appointment letter may not necessarily apply to all of those assets. Set out whether the receiver is to carry on the debtor's business or take possession of all or certain of the debtor's assets, and contain an acceptance by the receiver of the appointment signed by the receiver. 2.1. 1. 3 Indemnity of receiver. In many cases, a privately appointed receiver will not accept an appointment without an indemnity from the secured creditor, indemnifying the receiver against all costs and liabilities incurred by it while acting as receiver, save and except for negligence and misconduct. This indemnity can be contained in the appointment letter itself or, more typically, is set out in a separate document to preserve confidentiality, since the receiver, as evidence of its appointment, often provides the appointment letter to third parties. 2.1. 1. 4 Duties of a secured creditor or receiver under the PPSA while in possession. A reasonable care once possession has been obtained. The secured creditor, which for the purposes of the duties under the PPSA includes its agent or privately appointed receiver, is subject to the duties of care under the PPSA. For example, S17. 1 of the PPSA provides that the secured creditor must use reasonable care in the custody and preservation of collateral in its possession. The secured party is entitled to deduct its reasonable expenses of realization from the amounts collected. Failure to comply with any of the obligations under S17 will render the secured creditor liable for any loss or damage caused by such failure. SS17. 3. N. 5. B. No contracting out waiver pursuant to S59. 5. The debtor cannot waive the provisions of SS17 and 63-66 of the PPSA. C. Commercially reasonable manner in connection with the disposition of the collateral by the secured creditor. The secured creditor also has duties imposed on it by S63 of the PPSA. The debtor cannot waive the duties imposed by S63. Pursuant to S63. 2. A secured creditor may dispose of the collateral by public sale, private sale, lease, or otherwise so long as every aspect of the disposition is commercially reasonable. Although security agreements may contain agreements by the debtor and secured creditor as to what will constitute a commercially reasonable disposition by the secured creditor, a court is not bound by such agreement. The PPSA does not define commercial reasonableness, so reference to the case law must be made to determine how the courts have interpreted the standards having regard to the facts and the particular circumstances in each case. Generally, the courts will look to the following factors. Did the secured creditor act in good faith? Based on a subjective standard, was reasonable care exercised by the secured creditor? Based on an objective standard, was the purchase price close to the fair market value of the collateral, as established by independent appraisal evidence? To establish that fair market value was obtained for the collateral, a secured creditor should obtain at least 2 independent appraisals of the collateral. If the appraisals are materially different in terms of valuation, a third appraisal should be obtained. The secured creditor should also ensure that the collateral is properly marketed and advertised in appropriate trade or industry publications and newspapers to obtain the best possible price for the collateral. D. Requirement to undertake reasonable repairs. A secured creditor may be required to undertake reasonable repairs to the collateral if such repairs will enhance the value of the collateral on disposition. Subsection 63. 1 of the PPSA provides that a secured creditor may dispose of any of the collateral in its possession either before or after any commercially reasonable repair, processing, or preparation for disposition. The case law suggests that failure to undertake repairs before disposition that would have resulted in a substantially higher sale price may result in a determination that the sale was not a commercially reasonable sale. E. Requirement to give notice of disposition of collateral. I. Requirement to give notice before a secured creditor is entitled to sell the collateral. It must first give notice of the intended disposition of the collateral, commonly referred to as a PPSA notice of disposition, to the debtor and other interested parties set out in the PPSA in order to give the debtor and others entitled to notice one last opportunity to redeem the indebtedness secured by the collateral before the collateral is sold by the secured creditor. 2. Who is entitled to receive notice. Subsection 63. 4 of the PPSA identifies those who are entitled to notice from the secured party, being the debtor, any owner of the collateral, any person who owes payment or performance of the obligation secured, including guarantors, any person who has a perfected security interest in the collateral under the PPSA, and every person with an interest in the collateral who has delivered a written notice to the secured party of the person's interest. 3. Notice period and content of notice. The notice must be given not less than 15 days prior to disposition of the collateral. The notice of disposition can be served on the debtor personally or by registered mail, prepaid courier, fax, or electronic transmission. S68. 1. Pursuant to S68. 4 of the PPSA, if the notice is sent by registered mail, the recipient is deemed to have received the notice 10 days following the mailing, resulting in a 25-day notice period. Subsection 63. 5 of the PPSA sets out what information must be contained in the notice, including the amount required to pay out the secured creditor and redeem the collateral. 4. Waivers and exemptions from notice. The debtor cannot contract out of its statutory right to receive notice and opportunity to redeem. S59. 5. However, S63(7) of the PPSA sets out certain situations where a notice of disposition is not required to be delivered. For example, notice is not required where the collateral is perishable or will decline speedily in value, or if a receiver is disposing of the collateral in the course of carrying on the debtor's business. In addition, S63(7)(f) provides that notice may be dispensed with if every person entitled to receive a notice under S63(4), including the debtor, consents in writing to the immediate disposition of the collateral v. Special notice required for fixtures and accessions if the secured creditor needs to remove fixtures from real property or accessions from other property before sale or foreclosure. The secured creditor must satisfy the special notice and other requirements under the PPSA. Pursuant to S34(5) of the PPSA, a secured creditor must provide at least 10 days written notice of its intention to remove a fixture from real property. A fixture is not defined in the PPSA, and reference to case law would be required to determine whether specific collateral constitutes a fixture for the purposes of S34(5). The notice of removal of fixtures is to be provided to each person who appears on the records of the proper land registry office to have an interest in the real property. The content of the notice is specified under S34(5). The secured creditor must reimburse any encumbrancer or owner of the real property other than the debtor for the cost of repairing any physical injury caused by removal, and may be required to give adequate security for the secured creditor's reimbursement obligation. SS34(3)(4). The obligation to reimburse does not include any diminution in value of the real property caused by the absence of the fixture nor the cost of any replacement. S34(3). Any person with an interest in the real property can retain the fixture by paying the secured creditor the indebtedness secured by the secured creditor's security interest. S34(7). Similarly, if any of the collateral constitutes an accession as defined in S1(1), S35(6) of the PPSA requires at least 10 days notice of the secured creditor's intention to remove an accession. The secured creditor's rights and obligations regarding the removal and reimbursement for the cost of repairing any physical injury, the provision of adequate security, the notice, the contents of the required notice, and the retention of the accession are similar to those relating to fixtures under S34, CSS 35, 4, 6, and 8. V. Consequences of non-compliance with notice requirements. If a secured creditor sells the assets of the debtor without providing notice in accordance with the PPSA, the debtor or anyone else with an interest in the collateral may hold the secured creditor liable for any damages or loss suffered by that person as a consequence of the noncompliance. S67(2). In spite of any noncompliance, a bona fide purchaser for value will still obtain clear title to the collateral. Subsection 63(10) of the PPSA provides that a purchaser for value of the assets in a public sale without knowledge of the defect in the sale and without collusion with the secured creditor, other bidders, or the person conducting the sale, and purchaser in good faith for value in the case of a disposition other than by public sale obtain the assets free and clear of the secured party's security interest, all subordinate security interests, and the debtor's interest. F. Delay of disposition. A secured creditor is not obligated to delay disposition of a debtor's assets until market conditions improve. Subsection 63(3) of the PPSA provides that a secured creditor may delay disposition of all or part of the collateral for such period of time as is commercially reasonable, although there may be circumstances when an immediate sale of security could be commercially unreasonable, such as when the secured creditor has not taken sufficient time to properly market the collateral for sale. The courts have not required secured creditors to delay disposition of collateral until poor market conditions improve, and instead have given precedence to a secured creditor's right to be repaid immediately. G. Purchase by secured creditor. Under the PPSA, a secured creditor can only purchase the collateral itself at a public sale, unless the court orders otherwise. S63(8). This restriction helps to ensure the most value can be obtained for the collateral. H. Duty to carry on the debtor's business. There is no obligation at common law or under the PPSA that requires a secured creditor to continue to operate an insolvent business. It would also not be commercially reasonable to force a secured creditor to assume the liabilities that arise in carrying on a debtor's business. 2.1.1.5 Duties under the BIA. In addition to the PPSA, the BIA also sets out certain statutory duties for secured creditors and receivers. both privately appointed and court-appointed. A definition of receiver under the BIA. A receiver is defined in S. 243, 2, of the BIA to be any person who has been appointed to take, or has taken, possession or control pursuant to a security agreement or order of a court of all or substantially all of an insolvent person's or bankrupt's inventory, accounts receivable, or other property used in the debtor's business. The definition of receiver contained in the BIA is so broad that it includes a secured creditor or its agent who takes possession or control of such property. However, pursuant to S. 243, 4, of the BIA, only a licensed trustee, in bankruptcy may be appointed as a receiver. B. Duty to act honestly, in good faith, and in a commercially reasonable manner. Paragraph 247, of the BIA imposes a general duty of good faith on a receiver, requiring that a receiver act honestly and in good faith. New amendments to the BIA also impose a duty of good faith on any interested person in any proceedings under the BIAS 4.2. 1. Paragraph 247, b, of the BIA requires that a receiver deal with the property of the insolvent person or the bankrupt in a commercially reasonable manner. The standard of commercial reasonableness is the same standard imposed on secured creditors and receivers under the PPSA, but is now coupled with an overriding obligation to also act in good faith. C. Reporting obligations under the BIAI. General obligation to give notice. A receiver's accountability to other creditors, the debtor, and the superintendent of bankruptcy is highlighted by the requirements under the BIA to provide notice to those interested persons of the receiver's appointment and information relating to the administration of the receivership, as soon as possible and no later than 10 days after its appointment. The BIA requires a receiver to report its appointment to the superintendent of bankruptcy. If the debtor is bankrupt, the receiver must also send a notice to the trustee in bankruptcy. If the debtor is not bankrupt, the receiver must also send a notice of its appointment to the insolvent person and to all creditors of the insolvent person that the receiver can identify after making reasonable efforts. S. 245. 1. After the initial notice, a receiver continues to have ongoing obligations to provide notice to any additional creditor of the debtor of whom it becomes aware at any point during the receivership. S. 245. 2. A receiver can obtain some assistance in this task from the insolvent debtor, who is required under S. 245. 3. Of the BIA to provide the receiver with the names and addresses of all creditors upon receipt of the receiver's notice of appointment. 2. Receiver reports immediately after taking control or possession of an insolvent debtor's assets. A receiver is required to prepare a statement or report in the prescribed form setting out the name and amount owing to each creditor, a list of the property in the possession or under the control of the receiver and the book value of each item, and the receiver's intended plan of action during the receivership. A copy of this initial statement is to be provided by the receiver to the superintendent of bankruptcy, the insolvent person or trustee in the case of bankruptcy, and any creditor of the insolvent person bankrupt who requests a copy at any time up to 6 months after the end of the receivership. BIA S. 246. 1. Bankruptcy and Insolvency General Rules. BIA Rules S. 125. At least once every 6 months after the preparation of the initial report, a receiver is required to prepare and send a copy to the same persons entitled to the initial report. An interim report setting out an interim statement of receipts and disbursements, all property that still remains under the receiver's possession or control, and information about the anticipated completion of the receivership. BIA S. 246. 2. BIA Rules S. 126. Upon completion of its duties as receiver, a receiver must prepare a final report and statement of accounts setting out the final statement of receipts and disbursements and details concerning the distribution of proceeds. BIA Rules S. 127. BIA S. 246. 3. Copies are to be sent to the same persons entitled to receive the initial and interim reports. Within 6 months after a copy of the statement of accounts is provided to the superintendent of bankruptcy, any person entitled to a copy of the final statement of accounts may apply to the court for review of the statement of accounts. S. 248. 2. The court may require a receiver to submit the statement of accounts for review, and the court may adjust, as it deems proper, the fees and charges of the receiver set out in such statement of accounts. Court-appointed receivers are exempted from this requirement pursuant to S. 243. 3. but the typical receivership appointment order will almost always contain a duty to submit its account to the court for review before its discharge. 2.1.1. 6 Court directions. Because they are officers of the court. Appointed receivers can easily obtain the directions and advice of the court with respect to certain controversial actions proposed to be taken by the receiver. Even though privately appointed, a private receiver is able to obtain the benefit of the court's advice and directions pursuant to S67 of the PPSA. That section provides that a receiver may apply for directions regarding the exercise of the receiver's rights or the discharge of the receiver's obligations under Part 5 or S17, 34, 3, or 35, 4, of the PPSA. In addition, secured creditors and privately appointed receivers may protect themselves by seeking the court's advice and directions with respect to the fulfillment of their duties under the BIA pursuant to S248, 1, of the BIA. 2.1.1. 7 Review powers of the court pursuant to S248, 1, of the BIA. The superintendent of bankruptcy, insolvent person or trustee in the case of bankruptcy, receiver, or creditor may, on an application to the court, require a review of the actions of a secured creditor, receiver, or insolvent person to determine if the receiver or insolvent person has satisfied its duties under SS 244-247 of the BIA. Note that the court's powers of review extends to secured creditors even if they do not qualify as receivers under S 243, 2, of the BIA. If the court is satisfied that the secured creditor, receiver, or insolvent debtor is not complying with the duties under SS 244-247 of the BIA, the court may make an order directing that the duty be carried out, or restraining the secured creditor or receiver, as applicable, from taking any steps to realize or otherwise deal with the property of the insolvent person until the receiver or secured creditor complies with the relevant duty. 21.2 Court receiverships. 2.1.2. 1. When are court-appointed receivers appropriate in certain cases? Even though a secured creditor has the contractual power to appoint a private receiver, it may be more appropriate or effective in the circumstances for the secured creditor to seek the appointment of a court-appointed receiver. The court appointment of a receiver may be considered advantageous in the following circumstances. The debtor has assets located outside of Canada. Foreign courts are much more likely to recognize the authority of a court-appointed receiver than a privately appointed receiver. Note that a receiver appointed under S101 of the CJA is appointed under provincial statute and, therefore, does not have authority in other provinces unless recognized by the relevant court in each province. Quebec courts will not recognize the authority of court-appointed receivers appointed under provincial statute. A receiver or interim receiver appointed under the BIA has national authority. There is a benefit to obtaining a stay of proceedings. A stay will restrain the exercise of a landlord's right of distress or its right to terminate a lease. The stay of proceedings would also prevent creditors from exercising remedies except with leave of the court and would also prevent other parties from terminating agreements and contracts with the debtor. Generally, to be granted leave, the party seeking leave will need to establish that it is being uniquely prejudiced by the stay and/or there will be no material prejudice to the debtor or its stakeholders as a result of lifting the stay. The court's supervision is beneficial to resolve disputes between different parties as to priority, value of the assets, and/or the appropriate path of realization. Since every step of the realization is court-supervised, a court receiver will provide a forum for court resolution of these types of disputes. The operation of the debtor's business may expose a receiver to certain liabilities. A court appointment may insulate the receiver from liabilities, such as environmental and/or labor-related issues. A quick sale of the debtor's assets is necessary. A court receivership will usually avoid having to comply with statutory notice provisions. The presence of the court is necessary to adjudicate a dispute between the debtor and secured creditor regarding whether there has been an event of default, entitling the secured creditor to appoint a receiver. 2.1.2. 2. The appointment and types of court receivers. A secured creditor can seek the appointment by the court of a receiver under S101 of the CJA if it is just or convenient to do so. An interim receiver pursuant to S47, 1, of the BIA, or a receiver under S243 of the BIA. For the appointment of a CJA receiver, the court must conclude that an order to appoint is just or convenient in light of the interests of all affected parties. such as where the property is at risk or where a privately appointed receiver is unable to enforce its security because the debtor refuses to surrender possession of its property to the secured creditor, or where the security agreement does not provide the privately appointed receiver with adequate powers in the circumstances. Even when a secured creditor is already in possession or there is a right of appointment of a receiver under the security agreement, a court may still exercise its discretion to appoint a receiver where the court is satisfied that the court's supervision and/or assistance is necessary to preserve the value of the property. 1. 2. 3 Powers of a court-appointed receiver. A court-appointed receiver is an officer of the court. It derives its powers solely from the court's order and takes its directions and instructions from the court and not the creditor who sought its appointment. B. Standard receivership order. The powers given to a court-appointed receiver are normally quite broad. To standardize and scale back the scope of such orders, the Commercial List Users Committee of the Ontario Superior Court of Justice has developed a standard template receivership order. Standard receivership order. Counsel for the applicant seeking the court's appointment of a receiver is expected to provide the court with a black-line version of the form of receivership appointment order being requested to show what changes are being requested that deviate from the standard receivership order. The standard receivership order includes the following powers of a court-appointed receiver: receive, preserve, protect, and maintain control of the debtor's assets, manage, operate, and carry on the business of the debtor, with powers to enter into any agreements or cease to perform any contracts of the debtor, engage consultants, experts, counsel, and other persons. Purchase or lease equipment, inventories, supplies, or other assets, settle, extend, or compromise any indebtedness owing to the debtor, initiate, prosecute, and continue the prosecution of proceedings and settle or compromise any such proceedings, market any or all of the debtor's assets, including advertise and solicit offers in respect thereof, sell, convey, transfer, lease, or assign any of the debtor's assets out of the ordinary course of business, with or without court approval depending on the purchase price, and convey any of the debtor's assets to purchasers, free and clear of any liens or encumbrances. 21.3 Personal liabilities of receivers. 2.1. 3. 1. General. The standard appointment order for a court-appointed receiver will almost always contain a first-ranking court-ordered receiver's charge over the debtor's assets to secure the fees, expenses, and liabilities incurred by the receiver during the court-ordered administration of the receivership. This receiver's charge will typically take precedence over existing security interests over the debtor's assets. Notwithstanding the receiver's charge, a court-appointed receiver, like a privately appointed receiver, will normally also require an indemnity from the creditor who sought its appointment to protect itself in the event that the assets subject to the receiver's charge are not sufficient to cover its potential liabilities. Since it is the creditor who appoints the receiver and accordingly it is the creditor who ensures that the receiver's fees are paid, such an indemnity will typically exclude any liability incurred by the receiver as a result of the receiver's gross negligence or willful misconduct. It is through these indemnities that receivers expose secured creditors to the risks and liabilities that may be incurred by a receiver. The two most common areas of concern for receivers are in the areas of labor and employment law and environmental law. 2.1. 3. 2. Labor issues and successor employer liabilities. A general. If a trustee in bankruptcy or receiver carries on the business of a debtor or bankrupt and seeks the assistance of any of the employees of the debtor or bankrupt, the trustee or receiver may be at risk of being found to be a successor employer for the purposes of the various employment-related legislation. The monetary consequences of a finding of successorship can be significant. Successor employer obligations can render trustees and receivers liable for such obligations as vacation pay, termination and severance obligations, and perhaps most significantly, pension plan obligations, all of which can add up to be in the millions of dollars. Amendments to the BIA, discussed below, were intended to address these concerns. B. Successor employer liabilities for non-unionized businesses in Ontario. The Employment Standards Act, 2000 ESA, governs the employment relationship between employers and non-unionized employees. The definition of employer in the ESA includes a receiver and trustee. If the trustee or receiver sells the business, the buyer of the business would be a successor employer and would assume those obligations. The concern arises when the trustee or receiver cannot find a buyer for the business. The trustee or receiver does not want to be considered to be a successor employer during the period that it operated the debtor's business. The Employment Standards Branch has, for the most part, alleviated this concern by clarifying its policy in connection with the treatment of trustees and receivers under the ESA. The branch has stated that a trustee or receiver manager who continues the business of a debtor with a view to seeking a going concern sale will not be considered by the branch to be a successor employer in the event that no sale is completed and the business is ultimately liquidated, as long as the time period that the business is being operated by the trustee or receiver is reasonably short in length. The longer employees are retained and the trustee or receiver operates the business before the decision is made to liquidate, the higher the risk that the branch may find that the business was not being operated with a view to selling the business. Employees who are retained by the trustee or receiver are generally retained on the basis of term and task letters that expressly set out the terms of short-term employment and the limited liability of the trustee or receiver. C. Successor employer issues for unionized businesses in Ontario. The Labour Relations Act, 1995, LRA, governs labor relations where there is a unionized workforce. Under S69 of the LRA, any person to whom a business is sold by an employer is bound by any collective agreement between the employer and its employees. The definition of sales for the purpose of the section includes leases, transfers and any other manner of disposition. The issue for trustees and receivers is whether the assumption of control of a business by a receiver can be considered a sale within the definition under the LRA. Being found to be a successor employer where there is a collective agreement can have significant consequences to the receiver and the administration of a receivership. As a successor employer, a trustee or receiver will be personally responsible for complying with the collective agreement while it is operating the business, which could include having to compensate employees for the debtor's breaches of the collective agreement that arose prior to the receiver's appointment. Further, a receiver could be bound to honor generous terms